Good afternoon and welcome to another edition of the Daily Fix. I am your usual host and presenter, Advocate Tudo Hoyani. This afternoon, as the court winds up the reply of Advocate Ngumalo, I just want to look at an issue that arose during the course of the proceedings. Judge Thabang Makeleni asked about Thabang Makeleni. You see, Makeleni is that controversial character who is supposed to be deceased, although no death certificate has been handed in to the court to actually confirm that Makeleni is not longer in this world. Now, Makeleni could not testify, of course, because he's reported to have been deceased. Now, the evidence of Makeleni comes to court through one warrant officer, Steenkamp. Sorry. One warrant officer, Steenkamp. Warrant officer Steenkamp himself did not testify. Another bizarre twist in this trial. He did not testify. He simply handed in an affidavit, in which affidavit he told the court that Thabang Makeleni had told him about what his observations were on the 26th of October 2014 outside the Khumalo house. But I've already traversed this Makeleni issue. According to that affidavit that warrant officer Steenkamp, made, and which was read into the record before the Pretoria High Court, Makeleni narrates a most bizarre story. A most bizarre story. You see, because the prosecution is bringing up the Makeleni affidavit made by warrant officer Steenkamp to try and deal with the non-identification of the intruders, the alleged two intruders who went into the house, and the other people who were supposed to be outside the house or in the car. So they come up with the evidence of Thabang Makeleni taken by warrant officer Steenkamp. Before I get into the evidence again, and I've dealt with this evidence, let me say this. Warrant officer Steenkamp is still alive, unlike Makeleni. Why was it necessary for the prosecution to only bring up an affidavit made by warrant officer Steenkamp? Because you see, my own take on that is that the defense should have objected to the handing in of that affidavit as an exhibit. Because, you see, once an affidavit is handed in as an exhibit, it becomes very problematic to deal with it. It is a piece of paper and it cannot be cross-examined. You see, some of the concerns that we have about the contents of that affidavit handed in as an exhibit are the following. You see, Makeleni is supposed to have seen people run out of the Khumalo house shortly after MEYIWA was shot and killed. These people came out of the house running. It is not even being alleged that as they came out of the house running, they uttered any words. or spoke to anyone. But mysteriously, Makeleni is supposed to have excuse me once more. Makeleni is supposed to have spotted a gold tooth in one of these people's mouths, or on one of these people. 8:30 p.m. to 9 o'clock in the evening, people come running out of the house, come out of the Kumalo house running. And the statement says Makeleni spotted a gold tooth on one of them. Herein lies the danger. The danger of having admitted that affidavit is that that affidavit makes these controversial, unbelievable disclosures, which cannot be cross-examined because they form part of an affidavit made by a warrant officer Steenkamp. So that affidavit cannot be cross-examined to establish the veracity of just what I have outlined to you. That how would, under those circumstances, how would Makeleni have spotted a gold tooth on one of these individuals? You know, given the suddenness of it, the whole thing happened very quickly. How is that possible? So had Makeleni been here, you know, he would have been cross-examined on that. But you see, warrant officer Steenkamp himself, you know, who took that statement, should have testified, because that warrant officer Steenkamp is still here with us, so that he could actually be, you know, he could be cross-examined on the contents of that statement to try and establish whether that statement has any credibility at all. You know, what did Steenkamp make of, you know, these disclosures being made to him? You know, how could he possibly have believed this kind of thing and taken it to be evidence, given the circumstances under which Makeleni is supposed to have made that observation? So, be that as it may, the affidavit by Steenkamp has been admitted as evidence. But that does not end the story, the issue does not end there, because the court still has to, you know, to say to itself, what kind of evidence is this? Is this the sort of evidence that can be relied upon for purposes of convicting the 5 men sitting in the Pretoria High Court? Would any reasonable court, having had sight of that affidavit in which Makeleni allegedly makes those disclosures, come to the conclusion that in fact Makeleni did spot a gold tooth on one of the intruders? Now, if you juxtapose that with the fact that both accused number 2 and 3, Bongani Ntanzi and Mtobisi Mngube, you know, the alleged people, the shifting narrative of the gold tooth went from Ntanzi at some stage, now it went to Mngube. But at the end of the day, none of them, no, they were, excuse me, this flu will never just go away. So, all I'm trying to say is, both of them, you know, were identified at different, or were examined rather, at different times by dental surgeons. And those dental surgeons determined that they never had gold teeth. So how then do you make, what then do you make of that evidence? You see, that evidence does not stand the test of time because it has been rubbished by the medical evidence. And the circumstances under which Makeleni is supposed to have made those observations are themselves dubious. So let us wait and see how the court deals with issues like this one. You'll also recall the court saying who introduced Thabang Makeleni, and Baloyi was quick to say it is Attorney Ramsipili. And Ramsipili stood up, Ramsipili said, no. Much as I cross-examined Zandi Kumalo about that statement, about the people inside the house, I never specifically addressed the issue of Makeleni, so that Makeleni could not have been introduced to the court by the defense. But that was really neither here nor there, because the most important thing is mention of Makeleni and the placing of, that affidavit on record, was made before this application for discharge was made. That is the bottom line. So the judge is enjoined to look into that kind of evidence and ask himself, is this the sort of evidence on which a reasonable court can convict? That is the bottom line. Having said that, let me thank you for watching this video. And let me thank you for the likes and the subscriptions and the shares that I'm seeing. I'm humbled by the overwhelming support that you have so far rendered to the Daily Fix. And I want to say to you, South Africa, and to you other viewers beyond the borders of South Africa, thank you very much, and have a wonderful, wonderful afternoon and evening.